Hello again, everyone, and welcome to Quigley on Divorce, a behind-the-scenes look. I'm your host, James Quigley. Thanks for joining today. Continuing on in the conversation about finances in divorce, I think today's conversation will be interesting for you. We're going to talk about the concept of maintenance. Maintenance, just as a term, so that you all understand, is a term formerly known as, and in some jurisdictions still known as, alimony. It's a form of spousal support. So separate from child support, it is a concept where, depending on the incomes of the parties in a marriage, depending on the length of the marriage, there may be a situation where a litigant is going to be required to pay a monthly amount, maintenance, to the other spouse, and that can be for a period of time. It can be reviewable, or it could be indefinite, which is specifically permanent, really, for all intents and purposes, until there's a change in circumstance. So I'm going to take a deeper dive into those concepts. But as we go through, let's back up a little bit, and let's just start about here in Illinois. What's a situation where someone would have to pay maintenance? What's the law? So it's interesting in Illinois, in I believe 2016, there was an overhaul of Illinois law. And what it did is it took away, I think, some of the discretion to a degree from judges in implementing more of a formulaic approach. Now, what the formula in Illinois does, it looks at household income as a starting point, okay? And also as a starting point, the court has to look at each party's respective income. So, for example, if you have a combined household income, $500,000 or less, you're likely going to be within the range of a formula. And I'm not going to get into the formula. It's pretty straightforward, but the concept generally, speaks to a 30% net kind of a number. It's not that easy. It's not that simple. But the concept is you look at spouse A, spouse B, what do they make? What's the disparity? You plug it into the formula, and the formula spits out the number. But it's not that easy, and this is something I think when we talk about a behind-the-scenes look, you're not going to see this in the statute, which is a lot of judges go from 0 to 60 and say, what are the numbers, and let's plug them in. As I mentioned, let's assume you have under $500,000 of combined household income. If you have somebody earning $280,000 in the marriage and the other spouse making $200,000, you could plug those two different numbers, both, 480 combined, you're under the 500 threshold, you plug it into the formula, it's going to spit out a number. It's not going to be that high because the disparity isn't that great. But what oftentimes happens in cases is you overlook the first step, the first requirement of the court, which is to determine whether or not it's a maintenance case. And so it's not just that there's a disparity in the income. You have to look at other factors to determine whether or not it really is a maintenance case. Can the one individual walking away with $200,000 of income support himself versus the $280,000 income supporting herself? I think most people would say by the time you pay taxes on that stuff, the delta between the two of them isn't that significant, such that the spouse making $200,000 could not support himself after the marriage. Now, the difference in their incomes is one of the things the court has to look at. You might look at the length of the marriage, look at the assets that are going to be distributed between them. If you say this is a 20-year plus marriage, okay, what's the significance of that? Well, 20 plus in Illinois puts you in the realm of indefinite maintenance, meaning the payor spouse is going to pay maintenance for so long as the payor is employed or unless there's a change in circumstance, okay? And in that circumstance, let's imagine the payor is the person making $280,000 and the person seeking maintenance is making $200,000. So 20 plus year marriage, if I'm a judge, I need to look at, by the way, is the payor capped out. In other words, maybe the payee, the one who wants maintenance, just recently got back into the workforce, is making $200,000, but has this tremendous upside. Maybe the person requesting maintenance is younger in the marriage and has a lot more years to work in maintenance and earn income. Those are some kind of things you have to look at, because it's not just a static look and say 280 versus 200, plug in the formula. But you have to be aware of this, and if you're working with an attorney, if you're getting divorced and you're in the middle of a case, you need to be asking these questions. Wait a minute, why are we calculating a maintenance number? My spouse makes $80,000 more than me, but, or less than me rather, but he's working, he's got a great job. He's about to be made manager or whatever the next step in his career, that in 2-3 years, he's going to be making $380 and I'm going to be making $280. Well, what happens in that? Well, you could say, well, that's fine. Then we adjust the numbers, we true up the numbers. Well, no, it doesn't work that way, because typically in a divorce, when there's an individual paying maintenance to the other, the person who's paying the maintenance waives his or her right to receive maintenance from the other person. So again, in this hypothetical we're talking about, let's say 280 has worked for 25 years, same company, is at a very high level position, is basically tapped out at 280,000. Probably going to get up to 300 maybe at some point, but that's really her trajectory, okay? Let's say dad was a stay-at-home dad for, 18, 20, 22 years of the marriage, but had some skills, talents, got himself this job now 3-4 years ago, making $200,000 a year, and he's killing it. And his trajectory is going up and up and up and up, okay? Well, if you ran a formula in 280 versus 200, there's going to be a maintenance payment, and the person making $280,000 is going to have to waive maintenance, so that in 2, 3, 4 years, all of a sudden he's making 380, 400, and she's now gone from 280 to 300 and doesn't get the benefit of any additional maintenance. So it cannot be, and you cannot allow your lawyer to allow a situation where there's a marginal difference in income to simply say, yeah, it's a maintenance case, run the formula. That's not the case. So that's something that's a little more nuanced, and it's something where I don't want to say there's a laziness, but there's just a reliance on, by many practitioners, many judges, plug a number into the formula, calculate out the number. The formula, by the way, in Illinois calculates out, based upon the number of months of your marriage, how long the term of the maintenance is, okay? And again, we talked about if you're married for 20 years or more in Illinois, then it can be indefinite. So again, if you're contemplating a divorce and you've been married 18, 19 years, you might want to consider, do I want to wait another year or two until we're past that 20, and then I don't have any options really in whether or not it's a permanent maintenance case. Now, at 18 years, in fact, anything over 10, you're in a situation where it is likely going to be reviewable, which means formula spits out the number of months that you're entitled to receive maintenance. When those number of months is up or expired, then that candidate may come back, depending on the circumstance, and say, hey, I still need more maintenance. When I started this, I was 56 years old, and now I've gotten this stuff, I'm 63. I'm not going to be able to get back in the workforce. I'm not going to be able to generate any meaningful income to support myself. So that person might get an extension of maintenance. So it's when you file matters in terms of the term length that you'll have to pay maintenance. But again, just to kind of put a bow on it, make sure if we're talking about plugging numbers into a formula, there's two things you have to consider. First, is it even a maintenance case? Who cares that one's making more than the other? The delta isn't significant enough that I think you should have to pay maintenance. Let's have that conversation, okay? Then the secondary conversation is, are your combined household incomes less than $500,000? Why is that relevant? Well, at least now the way the statute here in Illinois is, they look to it's sort of a trigger point. If you have somebody who, let's say the combined incomes are 7 figures, are in the significant, 6, 7, 800,000s, okay? The court has a little broader discretion in those cases to say what are the needs of the recipient spouse. So let's say you have a little different scenario than we talked about. Let's say you now have someone making $1 million a year, and the other spouse, and I'll flip-flop this, in this case, let's for the hypothetical, husband's now the primary earner, and he's making $1 million a year, and the wife raised the 2 kids, the 3 kids, and for basically 20 years had not worked outside of the home, put all of her efforts into raising the kids and helping support the husband grow his career and all of these things that they did as a team, they did as a partnership, right? Now the kids are grown, and husband and wife are getting a divorce, and he's making $1 million a year. That's not a case that you automatically just plug into the formula, because their lifestyle over 25 years is different. Now, if it wasn't a situation where we raised a bunch of kids and 25 years of marriage, but it's an 11-year marriage, and maybe we don't have kids, okay? The lifestyle one had in the ability for someone after 11 years of marriage to go and maybe get back on their own feet might be looked at differently, okay? So at those high wage earner cases, lifestyle becomes a relevant consideration. Now, let me be clear, because we get this oftentimes. People come in and say, wait a minute, aren't I entitled to live the standard of living I enjoyed during the marriage? Aside from the fact that anytime anybody starts a conversation with me about them being entitled to anything, we got a problem. But that said, that's not what the law is. You're not entitled to live in the same standard of living that you enjoyed during the marriage after divorce. It is a factor the court can consider in determining the appropriate amount of maintenance to be paid on a monthly basis and the length of that. Now, one of the things that you should also know, here's behind the scenes, right? You don't see this in a statute book. Nobody tells you this, okay? In my 30 years of doing this, I can, there's certain firms, certain lawyers I know, they do this out of habit, okay? They get a litigant who has been home, say it's the 25-year homemaker mother, worked really hard, helped support the husband's career, building it up, and now getting a divorce. And what they say to their client is, go spend. Go spend so that you can create this extravagant lifestyle on paper. It looks like you're spending more each month. Probably the dumbest advice I've seen, because what it ends up doing is causing people to waste money buying things, doing things that they don't need or normally wouldn't have done. And they're not going to be compensated anymore for it, okay? What it does oftentimes as well is it creates a dissipation argument. What's dissipation? Dissipation is when you take marital money and you waste it. In simple terms, you use it for some non-marital purpose, okay? I go out and I blow, $30,000 on a fur coat. Okay, that's a dissipation. If we're still married, it's not a lifestyle issue. You don't go buy $30,000 fur coats. I spent $30,000 and I bought a purse. It's dissipation. So if you've got a lawyer that's telling you, hey, go out and spend. He just filed for divorce. You just filed for divorce. Spend, spend, spend. Take these wildly lavish vacations. Do all of this stuff that you never did during the marriage. It's not going to matter. Nor is it going to matter if during the marriage you've spent and you've lived this really nice lifestyle, but now you're getting a divorce and someone's in a different home, and so you've got split expenses, and all of a sudden now, by the way, you're downsizing because with the divorce, you move into a home that's maybe not quite as nice, it's not as expensive. It's not going to diminish your maintenance. So don't be misled. I'm telling you, it is an effort that is going to backfire. It's usually an effort that benefits the lawyers because it creates more litigation and dissipation and ultimately defending against a maintenance claim. That's outrageous. Okay? Now, there are clearly certain circumstances where one's lifestyle is going to impact the maintenance award. Here's for instance, okay? Recently had a case where the party's husband made substantial money, several $1 million a year, and the expenses of my client were substantial, $50,000, $60,000 a month, okay? Well, the other side said that's not a realistic expenditure on a monthly basis because it included, she had some challenges with addictions, treatment programs, counselors, therapists, all the things one would normally do in a recovery to help, get themselves well. Well, if you're in a situation in the case where then the other side's alleging, that should impact other issues in the case because she's not well, then that's reasonably likely to have those expenses moving forward in that person's lifetime. So that is a relevant consideration. And that person's going to need some help because in a marriage, when you get married, what happens during your marriage is going to matter. If, God forbid, and I had this in another case, I had a client who had a very, very bad accident, and for all intents and purposes, to use the old term, and I don't know if it's inappropriate, but it's sort of a vegetable. Loss of function, paralysis, even cognitive loss. Very, very sad case. Happened during the marriage. Now, it was through no fault of the husband that this happened, but when you marry somebody and you take those vows, that matters. It matters legally. You don't get to say, well, I'm going to divorce this person now. Let the state take care of her. Let somebody else deal with it. It doesn't work that way. The court can look at you and say, you are going to have to provide for this individual in some measure, maybe for the rest of your life. And you could look at that and say, well, that's not fair. Well, that's part of what being married is. And that's something the laws look at the commitments you make to one another, this partnership that you've created. You can't just throw a partner out because something happened to them, okay? And so you always have to be cognizant of what the facts of that particular marriage are. Yes, you've got this high income wage earner, somebody making more than $500,000 a year, okay? What was the individual's role in the marriage? What did they do? Raising children is, I would argue, as with my own 4 children, my wife's role raising children, sacrificing her career, far more valuable. I mean, now we've got this of record. If she divorces me, that's on record. But it is recognized in the law that that contribution to a partnership, raising children, caring for children, supporting another spouse in his or her career, helping that person to grow. That's what a partnership is. We sometimes do different things. And so maintenance is the balancing act of that in the final analysis. Someone's raised the children. They made sure the kids got back and forth to the Little League games, to the soccer games, to the music recitals, to all of the different things, day in, day out, picking up the kids, getting them to school, packing lunches, all of the things that person's job does, that you don't get a paycheck for. This person's over here making a paycheck. This person doesn't get to ride off into the sunset and say, well, I'm good, I got a great job, you helped build up my career. No, you're going to have to support that other individual, your former partner, in some equitable way. So again, higher income wage earners, the courts can look at all of the factors of your particular marriage, and they can determine that, you know what, we could still take someone making $1 million a year and put that number into the formula. The formula is still going to spit out a number. It's going to, there's an extrapolator built into the formula such that it'll calculate it even though you're above that $500,000 threshold. But oftentimes, that's a very conservative number. And admittedly, with the new formula in around 2016, with child support and maintenance award in Illinois, hands down, have gone down. No one will argue that. It has had, and I don't want to say it's oppressive, some might argue maybe they were too liberal back in the past. Maybe now they're too conservative. I don't know. But without any real argument, numbers are generally down. You don't see cases where, in these days, very often, an individual, for example, gets 50% of the income, the marital income, on a forward-going basis. That's just not something you see. But in the old days, there would be those circumstances, depending on the factors of a marriage, depending on the length of the marriage, that could happen. So, again, if you're in a bracket where you have a high income wage earner, and those are the ones where, again, our experience, the kind of cases we handle sometimes, it requires a particular kind of experience, because it's not just a sort of myopic look into plug it into a formula and that's the number. That can be a good starting point, but then when it spits out a number and you say, wow, the number spit out is $18,000 a month, and historically someone's been spending $50,000 a month. Wait a minute, this is not equitable. And we have to look at the circumstances why. The reality for some situations, maybe the length of the marriage is short, maybe there wasn't somebody who was home raising children. That person may not have the duration nor the amount of maintenance on a forward-going basis. Another factor is, what does the marital estate consist of? And we talked about in a previous episode, marital versus non-marital property. Let's say somebody isn't a wage earner during the marriage, but they come from a family of great wealth, and they have trusts set up, and they're going to inherit tens of millions of dollars. Well, that's a factor. Why do you need maintenance if you're going to have tens of millions of dollars? And yeah, you got a guy over here or a gal over here making $1 million a year, but this individual doesn't have tens of millions of dollars in a trust for him or her, or it isn't coming in an inheritance. It's a factor to be considered. When you look at the assets of the marriage, let's say you have a situation where you have a 25-year marriage, because we've been using that number, 25-year marriage, and it's a $20 million estate. And roughly speaking, let's say it plays itself out that each party is going to get $10 million. And assume after a 25-year marriage, let's say the parties are in their, let's make them 60, okay? And so you've got $10 million, you're 60 years old, and you've got someone at 60 who's still working, making $1 million. Is it a maintenance case? Sure. Is it something where maybe there's a buyout and there's a negotiation where maybe instead of giving the one spouse $10 million, you give them $10,500,000 or $11 million and say, we're not gonna do maintenance. I'm buying you out of the concept of maintenance. Could somebody at 60 be okay with $10 million? Maybe. Maybe you'd be surprised, maybe you wouldn't, when you see people worth $10, $20 million and they say, I can't live off of $10 million. I'm going to be broke in 10 years. That might sound silly, but you maybe would be shocked when you see how some people, some families spend money. And that can be a factor too. That's the lifestyle you guys had. Every dollar you made, you blew it. And but for this, big windfall here, you guys wouldn't have 10 million or 20 million. So assets matter, the division of assets, because again, the analysis the court is really considering is, can you support yourself after this divorce comfortably? Can you live somewhat within reason? And what the conversation always really centers around is comparing A to B. Is this person going to have this dramatically wild, amazing lifestyle? This person's going to be nice, but there's the wide discrepancy because, this person's got the income potential, some deals are pending, some inheritance is on the way, whatever it is. The courts are courts of equity, okay? And equity implies fairness. fairness, despite what you hear in the world today, doesn't mean equal. It never does. Nothing is ever equal. It's never, in a marriage, people's roles, people's contributions are rarely equal, okay? They can be different and they can be as valuable here and there, but equity is more of a concept of fairness. And the courts have broad discretion. They can look at your case. They can look at your contribution, and sometimes these questions, unfortunately, don't really play out until a trial. Because you have one spouse, say the earner is saying, why does he need all this maintenance from me? I'm the one that went out and killed it from 9 to 5 every day. I worked 60, 70 hours a week. Well, that might be an argument if the other person, if the guy stayed home and was a ne'er-do-well and had some inheritance and basically went to the gym for 3-4 hours a day and, golfing another 2 hours a day and then came home and expected dinner to be made. Well, yeah, maybe that's a different scenario. But it really does require the courts to take a holistic look. And sometimes one spouse doesn't value the contribution of the other. And that's where, again, sometimes you have to put a witness on the witness stand. Have them tell them about the standard of living they've enjoyed. Have them describe some of the things they've done, the trips they've done. I've used huge demonstrative exhibits in the past. I had a huge trial, big maintenance case. In fact, I think it's a case that at the time out in DuPage County was one of the largest maintenance awards that had been obtained on a trial verdict. And one of the things we did in that trial is we brought in massive blow-up cardboard pictures of certain things. If you saw the house on Lake Michigan and you talked about it, now it sounds nice, they got a nice place on Lake Michigan, but then you see these photographs and the opulence and the money where they've spent six figures on a table from Europe in the main dining area. I mean, when you understand the stuff and you can see it, and you can have an individual that's credible sitting up there and say, we did this and we bought this, and I had a credit card every month and I spent, and my shopping was always at Neiman Marcus. I didn't do Target, I didn't do TJ Maxx. I mean, that was the lifestyle. It'd be nothing for me to spend, $30,000 a month on a credit card alone, let alone traveling the world. We flew private versus, regular coach. I mean, I had a case where literally the maintenance evolved around the added cost for private airfare. These people and their children always flew private. And so that was a standard of living, and that was something that, we all took into consideration because that was their life. So maintenance is a very individual look. And I guess what I'm saying is, if you have a unique set of circumstances, you have to let that be known to your attorney. You have to talk that through, because sometimes with the amount of divorce cases that are filed every single year, judges don't always have that time to take that deep delve into what is your life, why are you asking for this extra maintenance? Okay. Sometimes they don't even have that time to really delve into, is it a maintenance case? It's just this sort of reflexive, what does the formula spit out? So when you're talking about maintenance, we have those fundamental concepts that you always have to start with. Is it a maintenance case? If it's a maintenance case, what's the standard of living? Is the income of the families, does it exceed that $500,000 threshold? And then you have to take a deeper dive. Now, sometimes this actually requires, as I have in a current case where we had to have a financial expert come into the case. And you say, well, does that cost money? Who pays for it? Yeah, it does. You have to pay a professional to come in. Sometimes they do that sort of forensic look in establishing what is your lifestyle. We have great paralegals on my team, and so oftentimes I can have my paralegals pouring through credit cards, bank statements, piecing together a spreadsheet to say, what does that lifestyle look like? You have to have some evidentiary basis. You can't just walk into court and say, well, I spend $50,000 a month. Show me. Prove that. It's your burden to establish your lifestyle with evidence, if that's a position you're taking saying we need to go outside of the formula. So as much as those cases can require you to spend more money to make more money, and the analysis is much different in the high income cases, if your household income is $500,000 or below, my advice to you is have your attorney or have us calculate that for you very quickly and early on to understand what that obligation is, both for the amount and the duration that you'd be required to pay. Bank that, put it to the side, and recognize that as much as that might really, really suck, probably not going to be an area where it's going to be worth your while paying lawyers and financial people and so forth to try a case fighting that. Fight the battles that you can win or that there's a legitimate argument to be made, okay? And again, your case, you could have a household combined income of $500,000 or less, but there might be other circumstances that maybe there's a special needs child. Maybe somebody, as I said before, is going to get inheritance. Maybe somebody has a trust. There's a lot of, maybe someone just got back into the workforce and their future trajectory from an earning standpoint is much greater than another partner's. So those are the kind of conversations you should be having with your attorney. And again, as much as a lawyer's perspective is when people fight, we make money. That's just the way it is. So we try to encourage people, if you're not going to win on a battle, let's fight a different one. Let's negotiate something here. Let's maybe negotiate for a greater percentage of the assets. There's a lot of different things we can do for clients, but if it's one of those things where you just feel like you shouldn't have to pay your spouse maintenance, that's probably something that your lawyer should disabuse you of. And then you get past that issue. But understand, there's some nuance to it. Don't just blindly have your lawyer say, well, plug it into the formula. Why? What are the other factors? What's significant in your marriage? Okay? Now, maintenance can be a big deal. And we can have a separate conversation. We'll do a separate episode on modification, but I'm going to leave you with this. Because you're paying maintenance today doesn't mean you're always going to pay maintenance. Even if it's an indefinite 20-plus year marriage, there's still the possibility to modify and or terminate maintenance. Many of you understand the concept of cohabitation. Cohabitation on a continuing conjugal basis, meaning it's not just a boyfriend-girlfriend relationship. It's almost a de facto marriage. You don't necessarily have to move in with someone even to be found to have cohabited. And if you cohabit after the marriage, that could terminate your maintenance, even if it's found out later. If you secretly, have this relationship, you kept it hidden, you're moving, you're sharing expenses, and 2 years later, the spouse finds out that you've been having this continuing conjugal relationship, you've been cohabiting, your maintenance could terminate retroactive back to the start of the cohabitation. So always, always, always talk to your lawyer if you're getting divorced and you're getting maintenance. What can terminate my maintenance obligation? By the way, if you have somebody making a significant amount of money and the other person very little, and there's maintenance and it's indefinite, then all of a sudden the person receiving maintenance has this wonderful career opportunity, boom, blows up and now is making at or near or maybe even more than the payor spouse. Payor spouse can come in and say, wait a minute, it's a change in circumstance. And it's substantial, it's significant. That person can now support him or herself. Maintenance should be terminated. What about the payor who's making, what did you say before, $280,000, great job, but gets aged out? Hey, Mac, you're 56 years old. Thank you for your 30 years of service, but here's your pink slip. I've had cases like that, literally. And that's a hard case to evidence that I'm not voluntarily leaving my job. They basically told me they're going to be fired and your name is going to be mud in the industry, or you can take a package and you're out of here. What happens in that situation? I'm not making $280,000. I don't have a job. I get a severance for a year. And then what? Well, what efforts are you looking at to get a new job? Where are you at in life age-wise? What does your industry look like for people that are 56 years old? These can be a basis to go back into court and say, hey, substantial change in circumstance, I can't afford to pay that maintenance. I got a job after 6 months of looking, every day it's all I was doing is looking for a job, but now my job went from 280 to 175. Okay, then you should pay less in maintenance. And sometimes that can be built into an actual language in an agreement that says if your income goes down to a certain amount, then the formula readjusts and you pay a different amount. Okay, bonuses, commissions, other things that factor into income. How do you calculate those for maintenance as well? You made $300,000 this year, you made $150 the year before that, and you made $600 the year before that. Well, what's an average income? Do you have a base? Maybe maintenance gets set off of a base, and then the percentage every time you get a commission, or maybe you get quarterly distributions. Then additional money is trued up so that you're paying what you should over the course of the year, but you're not expected to pay maintenance every month off of the highest number, $600,000 3 years ago, when your base is only $125, for example. So there's a lot of nuance to it. It's not every case, comes with, hey, I make $200,000 and I get a bonus of $80,000 every year. That's my income. It's far more complicated. Stock options, restricted stock, when they're exercised and that becomes income. How does that work? So the conversation today is very broad, and I understand that. The real message is, if you're in a divorce, if you're in contemplation of a divorce, or even if you're after divorce and you've got changes in your circumstance, these are conversations you have to sit down with an experienced divorce attorney and understand their circumstances, your circumstances. Is it a maintenance case? What about these other factors? What about how it gets paid? Because I get paid this way. And what about all of these other things we talked about? It is a lot more nuanced than maybe just saying, hey, you make more than this person, plug it into the formula, and that spits out a number. So I hope this is helpful. I understand when we have these conversations, it's for a limited period of time, and we're just really scratching the surface on it. But maintenance can be an involved conversation. It's one you should always have with an experienced divorce attorney. Always happy to talk to you. If you have a conversation or a question about maintenance, you can always call me. My direct extension is 312-621-1225. And, of course, my email address, jmquigley@beermannlaw.com, 2 E's and 2 N's in Beermann. And if there's anything you need to know about the firm, or if you're ever interested in learning more about us at Beermann, it's www.beermannlaw.com. So thanks again for tuning in, for listening and watching. Look forward to seeing you at the next episode. Take care.